Hello, thank you for tuning into the YouTube channel. This is Jack Sung, immigration attorney. In this video, we're going to be talking about the latest rumor that surrounds the Day One CPT program. So first of all, Day One CPT is basically a work permit that's given through the school when one signs up for like a master's degree program or sometimes PhD program so that they can work for an employer and use the practical training experience for school credits. So this program is useful in the sense that a lot of people when their OPT ends and they didn't get selected in the lottery for the H-1B, they go back to school and ask the school to give them work permission so that they can continue working for the employer whom they have worked for or have been working for on OPT. So this is widely known as the quick fix for people who didn't get selected in the H-1B lottery and whose OPT is ending. Now, lately there's been a lot of rumor about how CPT is going to be under the attack and it's going to be a problem to use CPT in the future, if you want to go back for visa stamping and this and that. There was a video out there done by, I guess, a reputable immigration lawyer that combined the latest unlawful presence memo and CPT, and somehow make this creative link between the two that says, well, if you were on OPT for a long time and then you go back to school and then get Day One CPT, continue working, that's going to be a problem later on, and you're going to be found to be out of status and accrue unlawful presence if the consular officer finds that that was a violation. So I think that's basically what the video was trying to say. Well, I mean, I wanted to say that I don't agree with that. Obviously, any abuse of the CPT program is going to be a problem later on for maintenance of status, and it can impact visa applications. What I mean is that, there are some schools that have been known to, do something wrong with the CPT program and take students without offering really, a meaningful curriculum. And the name that comes to mind is like something called Tri-Valley. I remember a couple years ago, I was dealing with the Tri-Valley school fiasco. What happened there was that I think the school was shut down because it had taken in students and taken their money, but it didn't really have a curriculum, and then they send the students out for like CPTs. So in those kind of situations, the students are actually victims, but they can be seen as willing participants in this scheme of things, especially if they know what they're getting themselves into. So a lot of students from Tri-Valley were required to explain why they signed up for the course and how they got their CPT and what their understanding was. And a lot of them got denied later on when they went to the U.S. Embassy to apply for a visa. So that, I think, is more of a unique situation. So right now, I don't think that participating in Day One CPT, assuming that the school doesn't get shut down, is going to be a problem, later on for applying for a visa. But obviously, when you go back home, and especially in India, when you apply for a student visa, there are some officers that are just particularly tough, and they might ask questions regarding the CPT just to figure out if you intended to study and what your plans are. I think that is fair game, especially for people who were already working on STEM OPT for a couple of years and didn't apply for H-1B or didn't get selected for H-1B, moved on to another Day One CPT program working for the same employer. I think that, as a consular officer, I would want to know, did you go to CPT just because you want to continue working for this employer and you never intended to study? I think this problem is worse for people who already have a master's degree and who got CPT through like a master's degree level program. So imagine like if you already did your MBA and you go back to school for another, master level degree, but all you were doing is going to work for the same employer that you were working for on OPT. I think that could bring some inquiries, but I don't think that I don't agree with the assertion that even if the consular officer were to find that that was not appropriate, it would somehow cause unlawful presence to start accruing. I don't think that's true. I think that unlawful presence would start to accrue only if the consular officer finds that the visa applicant was a willing participant in some kind of a fraudulent scheme, to abuse the CPT system, like for example in the Tri-Valley University situation. Even in that situation, not all students were found to be willing participants. Only I think a few of them either confessed to knowing that this is just a scheme to continue working, and then they participated in it. But the rest of the students were still presumed to be innocent, and they were able to get their visa and move on with their life, or maybe transfer to a different school or do a change of status, and their H-1Bs were able to get approved, as far as I know. Now, in this day and age where Trump is the president, obviously a lot has changed, and right now there's a clamping down, on this particular area, meaning F1 student, OPT, H-1B. So, although I don't think that the government is going to go as far as, rendering people unlawfully present in the U.S. after the fact that, that they participated in a day one CPT when they were applying for a visa, it is difficult to kind of predict what the government's going to do. But as far as I know right now, CPT is still a valid option to continue work authorization post, OPT if you don't get selected in the lottery. So that's still a good way to go, but make sure when you select the school that it has a good reputation and that it's not just taking your money and not offering anything other than CPT. Gather the information and make an educated decision on the selection of your CPT education program. And if you already have a master's degree, perhaps think about how the second master's degree is going to help you in the long run, and choose your degree wisely as it relates to your first degree, but not like a substantially similar one where it seems like you're just repeating the same degree. That's what I would say about the CPT program right now. I definitely don't think that the unlawful presence memo is directed at the CPT program in any way. I mean, I don't think that it mentions CPT to any extent in the unlawful presence memo. It just basically says that after August 9th or August 8th or whenever, the unlawful presence will start to attach to F1 students who violated their status. In the olden days, F1 is duration of status, so there is hardly any unlawful presence unless the status holder is found to have committed some serious violations that cause them to lose their status. But now that's going to change, which means that if you're a student and you overstayed, then you overstay more than 180 days, you might be subject to bans when you leave the United States. But that doesn't really have much to do with CPT. So the only scenario that I think this could possibly come up in the CPT context is if the CPT is shut down, the school is shut down because of violating some CPT rule or some other international school rules, and the student is deemed to have participated in some kind of a fraudulent scheme with the school or somehow did something wrong with the CPT program that they're offered, and later on, because of the school is shut down, then they get dragged into this whole enforcement problem with ICE about their CPT use. In that situation, if there is clear evidence that the student had already violated their status, then yes, the unlawful presence memo would then come into play and say, well, probably, the student had already lost status, sometime during their CPT time. I mean, it's possible, but I highly doubt that that's going to be applied, throughout the entire landscape against all the, F1 students. So I don't think there's anything to worry about that right now, although that video is, causing a lot of concern. But to me, I mean, there's still more steps in between before a student would be found to have violated status and be barred from being able to come back. But, it is certainly also possible that if you use a lot of CPT or you've been working a lot on OPT and CPT and it doesn't seem like your intention is to study, your student visa subsequently could still be denied because of what they perceive to be CPT abuse. It's not a ban, but they could still refuse to give you a visa, which is not really a ban, but it wouldn't allow you to get a visa to come back, which is probably the same effect. And I haven't had any H-1B clients who use CPT that were denied visas outside the United States yet. And we've had a few from India that, that used CPT and later on got H-1B and they were able to get visas to come back. So I would say at this point, there isn't a whole lot of concern there yet, but we'll keep our ears to the ground. And if anything comes up, then obviously, we'll have another video and we'll let you know. And if you have any questions, feel free to reach out to me directly, and I'll be more than happy to answer your questions. And I usually respond pretty quickly. You can email me or find me on any social media platforms, or use the contact information that's included in the channel to reach me directly. Thank you. Have a good day.